Hey, what's going on, everybody? This is Tim Lowe with Signature Real Estate Group. I've got a special guest for you today. It's Gary Fales with the law offices of Gary Fales. We wanted to give people a quick heads up on how to protect yourself, whether you have an asset or if you don't have an asset. And Gary's going to go over those particular points. And whether it's protecting your kids or protecting your assets, that's what we're going to get into. So everybody, Gary Fales.
Hi there. Well, I'm happy to be here. I wanted to just kind of give a little introduction as to what it is that I do. So I'm an estate planning and asset protection attorney, which basically means that I prepare wills and trusts for folks. And I work with a lot of realtors over the years. I've done a lot of CE classes. And the reason for that is realtors are interfacing with folks who their number one asset normally is their home. And if you have a piece of real estate in your name at the time of your death, then you're going to go through this process called probate. And probate is expensive, it's time consuming and public in nature. And we don't want to have to go through that process, particularly because of the fees. It can cost up to 5% of the fair market value of your real estate and of anything else that ends up in probate. And that's money, of course, that quickly adds up. You just have to do a little math to figure out how much might probate cost me. And so living trusts are used for those who own a home, and it's like a bucket. And so you'll take the home after creating the bucket and you just simply put it in the bucket. And now you don't own it for probate purposes, although you continue to control it. And so in any event, I know you're going to ask me some questions about it, but I just kind of wanted to get that introduction going.
Yeah, absolutely. And I guess one of the bigger things with probate is it's time consuming as well, and things are locked up.
Yeah. And of course, anyone, your neighbor who is complaining about the leaves falling on your lawn, they can find out what your family got once you died. And I don't know about you, but I really don't want financial predators up at 3 a.m. finding out what my family got. So it's public as well.
Well, that and houses are kind of a living entity in themselves. To say you have a water leak and the house is vacant, nothing's been figured out with it yet, and now you've got issues that way, and it just creates a havoc of issues before things are settled.
Yeah. So the living trust is, generally speaking, not a substitute for a will. There's a lot of confusion with people about, well, if I have a will, doesn't that avoid probate? The will is actually your ticket to the probate court because the will is actually written to the court. You can't take a will into a bank and say, well, my dad died, here's the will. They're going to look at you weird. It has to be probated first, and then the court issues something called letters testamentary. And so when we have a trust, of course, we're going to use a will, but only as an emergency backup. In other words, remember that bucket, it owns the real estate and the rental properties and your bank account, it owns everything. But what happens after 10 years, you buy a new piece of property and you forget to put it in, and then you die. Well, there's going to be a probate on that house. But in probate, we want to make sure that it gets to the right people. So the trust should always be associated with a backup will, just in case you forget to put something in your trust. So I'm bringing that up because I get a lot of questions about that. And so that's how they work together. Now, some folks, if they don't have a piece of real estate, a home, they may not need a living trust, especially if they don't have a lot of other types of assets. So if you have under $25,000 of other assets and you don't have any real estate, there's probably not going to be a probate. So you should just do a will, a basic will, to make sure that there's no confusion among your beneficiaries and with the court, if it gets to that point, as to who might be receiving your stuff.
I think that's a great point. I mean, there's a lot of people out there that are renting, and they're not in a position to own any assets. And it is important to protect, say something happens to them where they're mentally not there anymore, they get into a tragic accident, and they need to make sure that their kids go to whomever they wish they're going to go to, and they don't want the government to dictate that.
That's right. So the will does appoint permanent guardians for minor children. And so, of course, a will is always something that you're going to do for somebody else. We would recommend that in addition, like the basic documents that I give to my kids when they turn 18 for their birthday is and they're not very excited about this, but I give them a will, I give them healthcare powers of attorney, and I give them financial powers of attorney. Those are the basic documents an 18-year-old needs to function without the government getting involved and trying to knock people out. Let's say you want your mom to do it or you want your sister to do it. It needs to be clear. It needs to be in writing.
Okay, that's a great point. And once they do, say they finally get out of that rental situation and get into a home, now that's when you're converting it up.
Yeah, you're going to roll it over. The will, of course, will need changed because when you have a trust, remember, it's that bucket. And when you have a trust, a will is nothing more than an emergency backup. And so when you roll it over to a trust, your plan, the will beneficiary no longer becomes your children or your sister. The beneficiary under the will becomes the trust. And we call that the pour over will because it pours everything back over into the trust. But once again, we don't want to rely on that pour over will. We want everything to be in the bucket at the time of your death. And that really is the biggest complaint. There will be a lot of people listening to this that have living trusts already. And the reason why they fail primarily is, once again, because time has gone by. They have this bucket, but it's empty. There's nothing in it. They bought a new home. They put it in their name at closing, and they never put it back in the bucket. And so there's a probate on that. And the kids are very surprised to hear that. So you really have to clean this up. I'm happy to review it. The laws change as well. We don't charge for reviewing other trusts. So yeah,
So when somebody is going to move to another house, they're going to sell one, move to the next house. How hard is it to make the changes with you on the trust?
It's not difficult. The primary thing they need to do, as long as the trust isn't outdated, which is another issue, the laws do change. The trust itself should be updated every so often. But when it comes to moving a new house in or a rental property, it's just a quick claim deed.
Okay.
Yeah, just have the title company do it. I don't really enjoy doing it.
Right.
The title companies can do it easy.
But as far as the trust goes, as far as any paperwork that needs to be explained within that document, it's
yeah, it's not difficult to do. Normally, when I do trust reviews, it's because the laws have changed and there's something going on in that trust, particularly with the taxes, that is completely outdated, and so that's kind of a whole nother topic. This is more of an introductory thing, but yeah,
sure.
if many of your folks don't have a living trust, by George, do something basic, and it's really not going to cost a whole lot. So for example, our fees will range anywhere from $1,300 for a single person to maybe $3,000. For a married couple, it's going to be more. So you're looking at maybe $2,300 to $4,500. It just so happens that this month I have a huge discount going on. I probably am hesitant to say what it is, but it's a lot cheaper than what I just told you. The reason I'm hesitant is because this video could make its rounds months from now.
Right.
And then I'd be like, oh, darn it. I'm not running that COVID special. I literally call it the COVID special because I can't do my marketing right now.
Oh, yeah, true. So in other words,
my classes, I can't teach. So I just having my assistant call past attendees and just letting them know I'm slashing all my prices. But it's not about the price as much as it is the peace of mind that everything's going to be okay if you get sick or ill or if you die.
Man, that's why I wanted to have you on, just for that simple fact, brother, how to protect yourself. Once you finally have these assets, you have to be able to send them to who you want to without the government getting involved, especially even with the children where they don't have any assets.
Yeah.
That will, and how to set it up correctly, like the cost on something like that. What are we looking at?
So if you do a basic will that is going to just basically give it outright to somebody, I would charge $99. Normally when I'm in that meeting, I'll tell them, look, you need to make sure that you're protecting yourself if in the event you lose your mind. And so we'll do what are called will packages for $495 if they're single, $795 if they're married. And those, once again, would be those basic documents that anybody needs. I don't care how much they have. I've had, women that are 95 years old, they don't have a whole lot, but you need to make sure that it's clear as to who's in charge. And like I said, I've had 18-year-olds. So the whole range of ages If they have no assets, really, you should still do at least a will and powers of attorney.
That's pretty minimal cost to have somebody oversee what needs to really be in those documents too,
Yeah,
and
I
where to
mean,
allocate them.
obviously, I'm not making any money on $99 wills, and you might wonder why are some attorneys doing $99 wills? Because we're betting on the fact that eventually there's going to be a probate. That's a
Yeah.
dirty little secret I just told you.
No, well, that's fine. I mean, you know what? But it serves a
No,
purpose.
I mean, I tell people that out in the open.
Yeah,
In
that's
fact,
fine.
sometimes
Absolutely.
I'm willing to do the will for free
Right.
just because I'm trying to emphasize the point that there's going to be a probate.
Yeah, you're going to have to start somewhere.
Yeah. And if there's that probate, how much do you think the attorney's going to get? A lot more than the trust.
Sure.
And so it's a technique that I use to help people understand, listen, wills are almost worthless. I mean, they're great if you have minor children,
Right.
but if you have a home and you only do a will, you're going to line the pockets of the attorneys.
Right. So you need that asset protection without a
Yeah,
doubt.
you need that living trust. Exactly.
Sure. Well, hey man, I appreciate you just giving everybody the skinny on
Yeah, hey, I got nothing to hide here. I'm happy to reveal everything.
You are the man. Appreciate it. I know you take care of a lot of signature real estate agents and their clients. So
Well, I try to tell them the truth. So we'll get together another time and we can talk about LLCs and stuff. There's a lot there too.
oh man, that's a whole different party. We'll jump back into
Yeah.
that too because that one's a good one.
Yeah.
Well, thanks for coming on and
Okay.
we'll
You got
definitely.
it. Best of luck. Stay safe out there.
All right, thanks, buddy. Talk to you
You
soon.
got it.